Good morning, everyone. It is September 15th, and I'd like to welcome you to the California Board of Accountancy. We are going to be opening today's session. I'd like to go ahead and start with a roll call, and let's go ahead and start with the board members on my right. If I could start with Ms. Kathleen Wright.
Kathleen Wright.
Jose Campos.
Carrie Ann Farrell-Hines.
Alicia Burha.
Michael Savoy.
Mark Silverman.
George Familette.
Dan Jacobson.
Sochi Leon.
Okay, thank you very much. We're going to go ahead and start with item 14 on the agenda, which is the presentation of oral argument on Superior Court remand in the matter of citation against Ned Liba, CPA license number 23912, case number CT-2016-1, and I'm going to go ahead and turn it over to our administrative law judge.
Good morning. Can you hear me okay?
There you go.
Okay. Good morning. I am Administrative Law Judge Carla L. Garrett with the Office of Administrative Hearings. I've been assigned to preside over this matter. I'd like to call the case for the record. We're here in the matter of the citation against Ned Allen Liba. This is before the Board of Accountancy. This is agency case number CT-20161, and this is OAH case number 2015-0904, 2015-090140. Just like to note for the record that the parties are present. And you know, I apologize. I called the case number that I just saw on an order, but I have a different case number, so I'm just going to call that just in case we're going to cover both sides, make sure that we're here on the same case. My OAH case number is 2017-08-0712. In any case, we're here for oral argument in a matter regarding a writ of mandate that was issued by the Superior Court with specific items in that order that the board is supposed to consider. One of those was oral argument. And so let me first go and get appearances from the parties. And let's begin first with the Deputy Attorney General.
Good morning, Your Honor. Stanton Lee from the Office of the Attorney General on behalf of the agency.
Good morning. And
good morning. I'm Ned Liba. I'm the respondent in this case.
good morning, Mr. Liba.
Your Honor, I would like to just acknowledge that board member Sunny Youngson Park is in the boardroom.
Yeah, I apologize for being late.
Okay, thank you. Okay, so you haven't missed anything. We just called the case. I understand there's some rules that were set forth outlining the scope of oral argument. It's part of my job to make sure we stay on point. We're only going to deal with the matters that were set forth in the order issued by the Superior Court. And I understand that each party is allowed 20 minutes apiece for argument and 10 minutes for rebuttal if need be. So with those rules in mind, I want to go first to you, Mr. Lee, and find out if there's any oral argument you wish to make at this time. And just for the record, I want both parties to know that I've read the extensive pleadings in this case, which is part of the reason why I have dark circles under my eyes today. I've read the pleadings, I've read through transcripts, I've read through arguments. So keeping in mind, you know, I don't mind having things emphasized, but I don't want a complete rehashing of what I've already read, just for whatever that's worth to any of the parties. So with that said, Mr. Lee, how do you wish to proceed?
We did not request oral argument.
Bring the microphone to you.
The agency in this matter did not request the oral argument. However, it is my understanding that there are new board members, and I'm prepared to provide a summary to those new board members of how this case got to be where it is now, as well as present the recommendations to the board.
Okay.
I'm ready.
This case started as a citation as a result of Mr. Liba not providing his fingerprints at the time that he submitted a renewal for licensure. Under 16 California Code of Regulations, Section 37.5, the board issued a citation for that failure to provide updated electronic fingerprints. Mr. Liba challenged that citation, and it proceeded to an administrative hearing before the Office of Administrative Hearings. A recommendation was issued. That recommendation was rejected by the board and was remanded to the Office of Administrative Hearings to take further evidence. That remand hearing was completed before a different administrative law judge, because the first administrative law judge was retiring. The second decision upheld the citation and gave Mr. Liba an opportunity to comply with the citation, which was to provide electronic fingerprints. Mr. Liba then petitioned for a writ of administrative mandate with the Superior Court, essentially challenging the decision and continuing to contest the basis for the citation itself. That petition went to oral arguments, there was written arguments, and the Superior Court issued a decision indicating that the board abused its discretion in upholding the citation, that there was not a basis for issuing the citation against Mr. Liba. And that was based on, well, in addition to that finding, it issued a remand order, granted the writ, sending the case back down before the board with instructions to issue a new decision in light of the Superior Court's opinion. The Superior Court found that Mr. Liba did in fact comply with 37.5. 37.5 has two parts to it, and the court believed that Mr. Liba did in fact submit his fingerprints as required by 37.5. The provision in 37.5 that the court agreed with was based on Mr. Liba's submission of fingerprint cards during his initial license application in the 1970s. So with that interpretation, the court concluded that yes, Mr. Liba already complied with 37.5. The board did not have authority to issue a citation for him not resubmitting additional fingerprints pursuant to the new regulation. There was an argument that was made that the purpose of 37.5 was to capture anybody who did not have an electronic fingerprint on file with the Department of Justice. And at hearing, we did present the chief of the Bureau of Criminal Information and Analysis for testimony. But because of the way that the database is maintained by the Department of Justice, there is no positive way to conclude or determine whether or not a particular individual has fingerprints in the database unless that person submits their fingerprints for cross-referencing. So the court ultimately said that we did not carry our burden in showing that, one, Mr. Liba had not submitted fingerprints because he submitted them in the 1970s with his initial application, and we did not show that an electronic copy of his records did not exist with the Department of Justice, that it could possibly exist. So that was the basis for granting the writ. It has been sent back down. It is my recommendation for the board that the board set aside its July 29th, 2017 order, which sustains the citation against Mr. Liba, that it then admit and consider the additional exhibits that the Superior Court ordered the board to consider, which were provided by Mr. Liba at the time of the oral arguments in the Superior Court case. After considering all that evidence, to then issue a new decision granting Mr. Liba's appeal of the citation and dismissing that citation against him. Thank you.
Thank you, Mr. Lee. And before I turn to you, Mr. Liba, with respect to the exhibits, have they been provided to the board? The exhibits that Mr. Liba, I'm sorry, what did I? No.
The supplemental
Yes.
records?
Yeah.
I believe so, Your Honor.
Okay, just wanted to make sure that that happened. Okay. So, Mr. Liba,
Yes,
I'm ready to hear your oral argument.
Thank you, Your Honor. I
Hang on for a second.
appreciate the opportunity.
Hang on just for a second. There's no need to swear in. This is just oral argument. Correct. I apologize, sir.
Should I proceed?
Yes, you may.
Thank you. I appreciate the opportunity to be here. I thank the summary and comments of my friend over here, Mr. Stanton Lee, so you have some good background on this. And I certainly do hope that you had an opportunity to review the documents that were admitted by order of the Superior Court, because those are important too. I do appreciate the opportunity to speak to you directly about this case. Administrative Law Judge Smith and Superior Court Judge Chang have spoken, and now the Attorney General, to recommend the dismissal of the citation against me. And I hope that the board will do that. But it's vitally important that the board deeply understand some of the substantive and procedural issues here. That's why I wanted to address you directly, not just for myself, but for similarly situated CPAs in California, because this matter involves a lot of other folks. Let me give you a brief outline of what I want to talk about. It's not going to be prolix, and it's not going to be too detailed. First, what is the literal meaning of this new regulation 37.5, the fingerprint?
So,
The new
Mr.
fingerprint, yes.
Mr. Liba, I'm going to give you an opportunity, obviously, to make your opening or your oral argument. I want to make sure that we adhere to the reasons, and this is not going to eat up your time, don't worry. I want to make sure we adhere to the reasons that we're here today. I appreciate oral argument, but we're here because of the writ of mandate issued by the Superior Court, and it was issued with specific items that needed to be addressed. And to the extent that we stay on that topic, I'm happy to hear what you have to say, but I just want to make sure we stay focused on that for.
My oral presentation is 15 minutes, and the reason we're here is because it was not clear to me that the board understood the issues in this case, and simply a ministerial dismissal of the citation would not address those issues. So I hope Your Honor will let me speak for 15 minutes. Everything I say here is part of the record. There's nothing I'm going to say that isn't part of the record or the decisions of Judge Smith or of Judge Chang.
Okay, I'm going to offer you latitude.
Okay.
And I'm going to give you 15 minutes.
The order was for 20 minutes, Your
Okay,
Honor.
I need for you to let me finish my sentence, number one. You just made a representation that you have 15 minutes, and I am agreeing with you. I'm going to give you your 15 minutes to make your oral argument, and I'm happy to hear that. If you need the additional 5 minutes, I'm happy to do that as well. I'm
Thank
not
you
here to
very
fight
much.
you. I'm not on either side here, okay?
All right.
Go ahead.
Again, to give you an idea of what I want to talk about, is the literal meaning of 37.5, just as Mr. Lee was discussing some elements of 37.5. The empirical standards that are in 37.5 that the board was not able to meet. I'm going to discuss some procedural irregularities that are recited in the decisions of Judge Smith and Judge Chang. And finally, I'm going to conclude with a prayer that you drop the citation and do a few other things, make some findings. First, I trust that everyone understands that when I speak of the CBA, I'm referring to the CBA staff and not necessarily specifically the members of this board. The DOJ is the Department of Justice. The AG is the Attorney General, represented by Stanton Lee. He was your attorney in this. CORI is an important word. Criminal Offender Record Information. There's federal and state CORI. Corey by statute includes fingerprints. So I ask you to make sure you've looked at Exhibit B to my written submission. Exhibit B are my January and February 2015 letters. These are letters with the CBA before there's any citation, when the question about the proper interpretation of 37.5 comes up. It shows, those letters back in January and February before the citation, shows that the CBA had my fingerprints in 1976, and furthermore, they could have had access, I claim, to the fingerprints that were held in the federal database. I observed the literal meaning of 37.5, and I quoted the key section, the key provision, or for those who did not use an electronic fingerprint system, which was me back in 1976. That's in that January letter. I asked for an opportunity to speak to someone on the board, as I did back in 2004 when we discussed 54.1, a regulation that you changed, I think, as a result of me and some other folks coming here saying, there's something wrong. Just having a conversation. I spoke to the president of the board at that time on the phone and in person. I asked for copies of documents viewed by the CBA representative during the January 2015 phone conversation, and documents in possession of the CBA that would show I had submitted fingerprints. I received no response. I followed up 5 times requesting those documents. That's all in the record. They said they had no documents. After the CBA cited and fined me, and after I appealed, and the case was under the jurisdiction of the Office of Administrative Hearing, then and only then, perhaps at the prompting of the Attorney General, did the CBA give me copies of my application to take the CPA exam and my application for licensing. Those documents showed that I had submitted fingerprints for licensing back in 1976. So please keep those documents in mind as I make my further comments. The literal meaning of 37.5, just a prosaic, casual, natural reading of 37.5. It requires certain licensees to complete a state and federal query search conducted through the Department of Justice. Those licensees who needed a new query search are those who, 1, who had not previously submitted fingerprints as a condition of licensing, or 2, for whom an electronic record of the licensee's fingerprints does not exist in the DOJ query database. So I'm a person who previously submitted fingerprints as a condition of licensing. I was not required to undertake any more effort. The next part of 37.5, which I quoted to you, the CBA in the very first letter, provides evidence on how you show you satisfy the requirements. As the regulation states, it's for those who did not use an electronic fingerprint system, a receipt. So you can see my written arguments. Hopefully you've had an opportunity to look at the written arguments and realize that not once during this entire proceeding, not once, did the CBA analyze that key section of 37.5, or for those who did not use an electronic fingerprint system. Not once, no pleadings, nothing. When Judge Chang interrupted the Attorney General in his oral arguments on March 10, 2017, he asked the Assistant Attorney General, or Deputy Attorney General, to explain the meaning of that specific provision. His answer was essentially as follows. The statement, for those who did not use an electronic fingerprint system, he said, that applied only to those who first used an electronic fingerprint system. You can see the verbatim statements from the transcript in my written submission. And I hope to hear from the board that you, in fact, do not support such a profound torturing of the meaning of your regulatory language. We have to be able to rely on the plain meaning of the language here. Judge Chang called that statement and other arguments not reasonable, an attempt to put a square peg in a round hole. She said it did not make any sense. The analysis and meaning of the words of 37.5 offered by Judge Chang and Judge Smith, they're extensive and they are cogent. CPAs like me, who were subject to fingerprinting as a condition of initial licensing, do not need to undertake any additional fingerprinting or Corey searches under 37.5. The next section is very important. It's the empirical findings. And there are three quick subjects here that are important. The first is a requirement in the regulation that there be a showing by the California Board of Accountancy that a licensee's fingerprints do not exist in the DOJ database. The most the CBA witness, a manager for the Department of Justice, could offer was that my fingerprints might not exist in the database. And you can see Judge Chang says that is insufficient to satisfy the requirement of the statute. Empirically, they did not have the evidence to show that my fingerprints did not exist. The record reflects over and over and over again, I made requests of the CBA to show where they asked the Department of Justice for my Corey information. Not one record, not one document was produced. Over and over and over again, I asked the Department of Justice for the documents that showed that they conducted a search. Not one record was produced. The testimony of the CBA witness revealed that she, as the manager at the Department of Justice, did not seem to know what a reconciliation was, couldn't say much about internal control. Incredibly, she said she did not look in the automatic criminal history system for my Corey information. And when I asked about external reports that would speak to the reliability of the Corey database, the Attorney General, your lawyer, objected. If you read the testimony, consider our written arguments and the written decision documents of Judge Smith and Judge Chang, you will see that the CBA and the Department of Justice systems are not adequate, at least in this case, to satisfy the standards of 37.5. Okay, the second empirical issue is the ability of the CBA to obtain Corey information without first submitting fingerprints. As Judge Smith noted, the CBA was wrong to contend that the Penal Code, specifically 11-142, prohibited the CBA from receiving Corey information. The CBA can obtain Corey information even if it did not submit fingerprints legally. That legal analysis has not been disputed by the Attorney General, and yet the CBA, even today on its website, repeats the claim that it cannot receive Corey information because of the effects of Penal Code Section 11-142. In fact, a CBA document admitted to evidence shows it can conduct searches, quote, based on exact names, dates of birth, and social security numbers, period. There was no mention in this document of having fingerprints. Judge Smith, in his decision, stated it was reasonable as an alternative for the CBA to access electronic fingerprint and Corey information from federal databases without requiring additional fingerprints. Thus, the CBA could lawfully access not only Corey information that existed on the California DOJ site, but also federal Corey information. I want you to know my Corey information exists. It is and was lawfully available to the CBA, and I made an offer of proof to that effect. Again, you can see the detailed analysis in Judge Smith's decision. Finally, the third empirical discovery from all this was that the CBA destroyed or lost fingerprints and many other records. There was no written explanation retained by the CBA that reflects the reasons, notifications, or details for such purges or losses. The CBA did not seem to have an inventory control, did not seem to maintain a library of internal forms, instructions, and procedures. I just happened to retain a copy of the CBA's update publication from many, many years ago. That old edition of Update explained how rolled fingerprints, such as my fingerprints, were subject to federal and state Corey processing, and clearance. That document was admitted into evidence, and Judge Smith made findings based on that publication. When I asked for similar documents that would explain the procedures, I got nothing back. They were gone, lost, misplaced. Let me briefly talk about procedural irregularities. If you recall my very first letter in January, February of 2015, months before there was any citation, I simply wanted to have a conversation with some of you, with the president, the chair, a member, so I could get a sense of what your thinking was on this subject. You know, perhaps it would provoke you to look at 37.5 and say, you know, maybe this is something that we need to look at and fix, just like you did with
Objection, Your Honor.
54.1.
I believe this goes beyond the scope of the purpose of why we're here today.
It's in my letter.
I'm going to sustain the objection. Everything, I'm granted you latitude, and I'm happy to hear the rest of your oral argument. You have about 6 minutes left before your 20 minutes is up.
Okay, as you can see from the attachments to my arguments, Exhibit C and D, I was not able until this very day to address the board. It seems there was a wedge driven between me and the ability to address the board. There are many serious procedural irregularities that make me believe I was treated unfairly and improperly. I urge you to read and consider carefully my petition for reconsideration that the CBA staff improperly refused to process. Consider our memorandum of points and authorities where we cite the repeated false statements by the CBA. Look at Exhibit 5 and 8 that were admitted into evidence by the Superior Court. That shows that my fingerprints, this is in September of 2016, were in the possession of the CBA. They had been given 3 copies of my fingerprints, and the CBA still refused to renew my license. At the hearing and in our court filings, I urged a decision on the narrow issue of the literal interpretation of 37.5. The other issues were secondary and would not need to be addressed if the court decided the narrow issue. That was something I said at the administrative level, and I said at the Superior Court. You don't need to go into the other issues. Nonetheless, both Judge Smith and Judge Chang went beyond the essentials to decide the case. Both found the CBA could not meet the empirical burdens. The CBA record systems are inadequate. There was no documentary evidence to back up important assertions. The testimony of CBA witnesses were not credible, and further, both Judge Smith and Judge Chang found procedural irregularities. Read Judge Smith's decision, and you'll be profoundly disturbed. For Judge Chang, simply ask yourself why she would twice question in her final written decision, quote, if the CBA truly were interested in protecting the public. Twice. She was prompted, I believe, to add that subjunctive strike twice because the arguments were not reasonable. The CBA action, quote, on a practical fairness level did not make any sense at all because the CBA refused to renew my license without just cause. My conclusion in prayer. First, I hope you will dismiss the citation consistent with the order of Judge Chang, the ruling of Judge Smith, and the recommendation of the Attorney General. Second, please consider the implications of applying proper literal meaning of 37.5. Consider the implications of the inadequacy of the CBA and DOJ record systems to meet the empirical standards in 37.5. Many CPAs were cited and fined under 37.5, and probably thousands undertook duplicated, retroactive live scan fingerprints, incurring unnecessary costs. And was there some substantial increase in the protection of the public from misapplication of 37.5 by the CBA? Has the CBA discovered a long list of undisclosed CPA felons through enforcement? I'd like to see the list, and you should too. The board should ponder appropriate action in respect to these concerns. Third, please consider how to better establish a mechanism for practitioners to communicate with you on these matters. I don't know your views. I find it hard to believe that they are deep and reflective on this subject, but I don't know. Finally, I urge the board to make formal findings so there will be clear guidance to CBA staff, the profession, and the public regarding the literal interpretation of 37.5, the empirical standards, and the procedural problems that are apparent in this case. Thank you.
Thank you, Mr. Liebe. I'm going to open the floor to the members of the board to see if they have any questions for any of the parties. I'm going to go first to Ms. Wright. You have any questions?
I do, and thank you for appearing. And if I could ask you 3 questions regarding your testimony here. First,
Well, let me just stop. That wasn't testimony. That was oral argument. So I just
Oral.
want to make sure we understand the distinction.
Thank you. And if any of my questions deviate from the path that you described a moment ago, just please let me know, because
Thank you.
they are from just my reading the material and my observations here. First off, regarding the CBA's response to what happened to the fingerprints that you presented in the 1970s when you were initially licensed, you I think indicated that there was no reason specified, and it was my general interpretation from reading the material that the CBA perceived that there was a security risk of keeping all of these fingerprint records on file when they were no longer going to require fingerprints going forward for licensees. I thought that was a reasonable
Okay, so I'm going to stop you
That's
because
not-
you're making a speech as opposed to asking a question, number one.
Okay.
Number two, we're here for a specific reason. The Superior Court issued an order, not for us to go back and rehash all the evidence. I granted Mr. Liebe some latitude because he did request an oral argument in this case, but I want to make sure any questions you have deal with any of the exhibits that the court asked the board to consider, or something in relation to why or something in relation to the reasons that the Superior Court sent this matter back for the board to consider some things. It's not something about your interpretation of 37.5 right now. It is what the court asked us to consider here today. So,
Okay, am I allowed to raise questions regarding what Mr. Liebe presented in his oral argument now, or no? Because my questions relate to his presentation.
well, this is not testimony. He made an oral argument. It's not testimony. And so that's number one. Secondly, it's just his perspective. And if yours differs from his, for whatever reason, that's not what we're here for today.
Okay, I can summarize my 3 comments very quickly. One,
Do you have a question?
It needs to be questioned.
yes,
If it's a question, I will allow it. If it's a comment, I really rather move the hearing along.
okay. Not to belabor the point. What I thought I heard was different from what I read in the document, so I am confused. You're asking me to make a decision. I would like to clarify my confusion. If that deviates from the path that you want us to take, that's fine. I'll live with my confusion.
What is your question?
My question is, I thought there was a reason for destroying the fingerprint records, and it was security. Mr. Liebe had indicated there was no reason.
That's not why we're here today.
Okay, then the second one is, the representation that fingerprints were submitted, that, Mr. Liebe says fingerprints were submitted. It was my understanding from reading the materials that the reason that was not acceptable, and I think this was in 2015, if I recall correctly.
Okay, you know what?
Ask the
I
question.
The question is
ask the
that
question.
truth, well, he said they were unacceptable. CBA says they were unacceptable because they asked for 2 fingerprint records instead of just 1.
Okay, I'm gonna
What's
stop
the-
you.
Okay,
I'm gonna stop you.
That's fine.
I'm gonna stop you because we're here for a specific purpose. You are trying to expand this beyond the scope of this hearing. And so I'm going to move on to our next panel member at this time. Mr. Campos, do you have
I
any
have
questions?
no questions.
Ms. Hines, do you have any questions?
I have no questions.
Ms. Burhoff, do you have any
I
questions?
have no questions.
Mr. Savoy, do you have any questions?
No, Your Honor.
Mr. Silverman, do you have any questions?
None, Your Honor.
Thank you. Ms. Park, do you have any questions?
No questions.
Mr. Familat, do you have
No
any
questions,
questions?
Your Honor.
Mr. Jacobson, do you have any questions?
Yes, I do, Your Honor. Mr. Liba, would you be willing at this point to voluntarily submit fingerprints?
Yes, and I have submitted fingerprints.
Thank you. Mr. Lee, does the Department of Justice or the board still have, as I understand, the one-card fingerprints that Mr. Liba submitted?
What happened was the cards were returned because they required a stipulation by the board to waive legal defenses. After the oral argument was conducted and completed by the Superior Court, and the writ was granted, Mr. Liba voluntarily submitted electronic fingerprints. Those prints were then processed retroactively to the renewal date in September, I believe, 2016.
30, yes.
And he's current and update, and the fingerprints are now in the system.
Thank you.
May I respond? I'm just going to direct you on some of these issues to
No,
Exhibit
there's no
5
question
and 8.
pending. Mr. Liba,
I-
there's no question pending
I
to
should have
you.
an opportunity to respond.
There's no question pending to you. The question was posed to Mr. Lee, and he answered the question. Now, I'm going to go to you. Ms. Leon, do you have any questions?
No questions.
Okay. Now, at this time, you are allowed 10 minutes for rebuttal if you find the need to express anything that you haven't had an opportunity to express. Any rebuttal oral argument you wish to make at this time, Mr. Lee?
No, Your Honor.
Mr. Liba?
Yes.
Okay.
Yeah, in respect to the question, just to factually clarify the fingerprint situation, if you look at Exhibit 5 and 8, you will see the correspondence, you'll see my fingerprints, you'll see the evidence that was admitted by the Superior Court over the objection of the Attorney General that shows the history of my submission of fingerprints, and that's why I could say in September they had multiple copies of my fingerprints that are processable. In terms of other issues, I'm just going to make a comment. This is being very, very narrowly construed. I encourage the board to have a hearing on some of these issues where we can discuss them more thoroughly. Thank you.
Okay, thank you. Well, that concludes the hearing at this time. I want to make sure, however, that we have those exhibits in the hands of the board members, but just in an act of make sure that, in an abundance of caution, I want to make sure that those particular documents are admitted into evidence, so to speak, for the purposes of this hearing. So those particular exhibits, how many do we have in number? I'm going to admit those exhibits that the Superior Court required this board to consider collectively as Exhibit A in this matter. Okay. I assume there's no objection, Mr. Lee?
No, Your Honor.
Okay. So that those exhibits are admitted. Unless there's anything further from any board members, I'm ready to go off the record. Anything further from the parties? Okay. This matter is deemed submitted as of this day. We are off the record. Thank you very much.
Thank you, Your Honor.
Thank you. We're going to go ahead and move on to item 16, the petition hearing for Molly Erin McGinnis, petition for reinstatement of revoked certificate.
Okay. So we are on the record in the matter of the petition for reinstatement of Molly McGinnis. This is again before the Board of Accountancy. This is OAH case number 2017070948. I'd like to note for the record that the parties are present, and I'd like for you to state your appearances for the record, beginning with the Deputy Attorney General.
Yes, good morning, Your Honor, members of the board. Deputy Attorney General Carl Sani.
appearing on behalf of the people of the state of California pursuant to Business and Professions Code, Section 5115.
Good morning, Mr. Sane, and our petitioner.
My name is Molly McGinnis.
Good morning, Ms. McGinnis.
Good morning.
I'm not sure if I said it for the record, but I am Administrative Law Judge Carla L. Garrett. I've been assigned to preside over this matter today. I'd like to note for the record that all members of the board are present. Is that correct?
Correct.
Okay. And so I'm going to first start with you, Mr. Sane. Are you wishing to summarize this case for us today?
Yes, Your Honor, and I would perhaps first like to mark for identification as Exhibit 1 the original petition packet with accompanying documents. The board members and the petitioners each have a copy of that packet. They are numbered MEM-PET001 to 116, and I'm going to refer to simply the page numbers as PET followed by the page numbers. The petition itself is located at PET 005 to 12. So, Your Honor, I would move to admit that Exhibit 1.
I've marked it accordingly as Exhibit 1. I assume there's no objection from you, Ms. McGinnis, for this
No.
document to come into evidence?
No, there's not.
Okay, so Exhibit 1 is received.
Thank you, Your Honor. I'd like to now just briefly give a summary of this case. The board has before it a memorandum by Mr. Dominic Franzella to the board dated July 31st, 2017. It's found at pages PET 1 to PET 3. And that comprises a summary of the case. I believe all the members have had an opportunity to review that summary. This case involves a variety of prior convictions of the respondent. Most, if not all, appear to be alcohol-related matters, the last conviction being in 2015. I, in the interest of brevity, won't summarize each and every conviction. The board members have that information before it. They're also described in the accusation, which was filed in this case, and that accusation is located starting on pages PET 98. So each of the convictions is described in further detail at that page. When Ms. McGinnis did not respond to this case, her license was revoked by operation of a default decision. And the timing of all that license information is contained in the certification of license history. The certification of license history, which details the original grant of license number 74486 to Ms. Molly McGinnis, occurred on November 21st, 1997. The details of her license history are found at pages PET 115 to 116. The causes of action in the accusation, again, were 7 convictions, I believe, and the 1 conviction for failure to report her convictions to the board. The packet contains 2 letters of recommendation, evidence of continuing education, and treatment in various alcohol recovery programs. Again, I will not detail those here at this time. With that, Your Honor, I would request that the witness be sworn in.
So I'm going to take this moment to swear you in, ma'am.
Okay.
You can just stay seated.
Okay.
You can raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Is it your intention, Mr. Sonny, to ask questions of this witness right now?
Yes, Your Honor, unless the petitioner wants to go first, I thought I may elicit some information from the witness.
Before I allow you to do that, I want to first go to Ms. McGinnis to find out. I know that Mr. Sonny provided a summary, and by way of, I consider that an opening statement. And I wanted to give you an opportunity, Ms. McGinnis, if you, to make an opening statement if you wish at this time. And you don't have to. It's just, I want to give you that opportunity if you so desire.
Okay. I just wanted the board to know that my profession is of utmost importance to me, as is my sobriety. And as you will see, my history of alcoholism was related to a lot of traumatic things that had happened to me. And nevertheless, I do take complete responsibility for all my actions.
Thank you very much, Ms. McGinnis. So I'm going to turn the floor back over to you, Mr. Sonnen, to find out, do you have any questions of this particular witness?
A few questions, Your Honor.
Okay.
Thank you. Ms. McGinnis, your petition is dated, I believe, in June, and you indicate in it your employment. Are you currently employed as indicated in your petition?
Yes, I am.
And, thank you. The petition also describes that your last conviction in 2015, you were in the process of reducing it from a felony to a misdemeanor. Can you give us an update where that process stands?
I'm working with attorney Matt McCormick, and he is, we have met, and we are in the process of setting a date and then getting some documents together to present to the judge to get it reduced to a misdemeanor.
Thank you. And I understand you served some time incarcerated.
I
for that
did.
matter?
I did. I served 10 months, upon which I was released on a community work program. And that lasted until, that's in lieu of jail time, you do community service work. And after that, that was through July. And in September, I got a job right after that. So-
Thank you. Your original documents contained in the accusation, or excuse me, the allegations contained in the accusation indicated that you were on probation for a period of 5 years following that 2015 conviction. Are you on probation today?
No, the sentence was changed from 1 year in to 1 year on probation. And so at this point, I'm off probation.
Okay, and that was as a function of the time actually served and your process of doing this community work program?
Yes.
Okay. What's the status of your driver's license?
Currently, I have a restricted license with a breathalyzer in the car. And I believe that'll be in the car for another year.
Thank you. Now, the purpose of this is not to go over the prior convictions, but really to talk about your rehabilitation process and the fact that you would be safe to practice. And one of the questions that naturally arises, though, when you review the convictions is at least 2 of your convictions involve blood alcohol levels that seem rather large at 0.37 and 0.49. Can you tell us what the state of your alcoholism was at that point and how that has changed to where you are today?
What happened to me was I clearly am predisposed to alcoholism. I'm 100% Irish, and then there are factors, other factors, genetics, and then certain environmental factors. I went through a really ugly divorce. And during that time, I turned to alcohol instead of asking for therapeutic help. I was devastated. I had 2 young kids, and my husband walked out on me. So it was really hard. It took me a long time to get over it. And it's hard to talk about it, but that's okay, because in the program of Alcoholics Anonymous, we believe in not letting go of our past, but also not holding on to it to carry us, to hold us down. We reflect on our past, but we focus on our future. And that's what I do in today, because what happened through the program of Alcoholics Anonymous and through the various programs I attended for recovery have helped me tremendously. I have an outlook now that involves more compassion for others and the presence of God in every day that I experience. I didn't look at life like that before. I was scared. I had a lot of fear. And now I don't have that fear. I have turned that fear into faith, and I've turned my shame into humility. And having reunited with my children, being gainfully employed, having a loving family and friends, you start to get things back if you work the program and you work it hard, which I do on a daily basis. And amazing things happen through sobriety. A person like me who's gone through a lot, made a lot of mistakes, hurt people, hurt myself, and then to be at this point where I can honestly say I have found a degree of peace that allows me to function in this world as a loving and respectful human being, professional, mother, daughter, and friend.
Thank you very much, Ms. McGinnis. Now, I understand at some point you lost custody of your children. Do you now share custody of your children?
Yes, my oldest son is now going to college. He's going to UC Santa Barbara. My youngest son just started high school, and we share time with him. It's 50-50.
Okay, now you mentioned that you're a participant in the AA program. Do you
Yes.
follow the 12-step program?
I do.
Can you tell us a little bit about that and what step you're on and a little bit how that
Sure.
is meaningful to you?
Yeah, I've been in AA for a while. I have really found that through my experience, what happened to me was when I relapsed, it's when I stopped going to meetings regularly. There's things that are so in the program that can be very easy, very simple, but if you start to lighten up on some areas, you can get in the danger zone. And I've learned that myself. And so I go to AA every week. I have a lot of friends in the program. And what I've really learned from other people is, in the program that is, how we can struggle with things, but at the same time, if we really have faith in a higher power, that's a whole different thing. Because for me, that was the spiritual awakening was what changed me. And that was all within, all with my higher power. And I can't say enough about it, how it changed my outlook on life. And it's just, AA brings with it so many wonderful things. Of course, sobriety is the big one. And being able to participate in life in a joyous and wonderful way, being a trusted and talented professional, it's just so much better. And I can't tell you how blessed I feel. Having gone through what I went through was hard, but having come out of it with an outlook of peace and serenity and compassion makes a world of difference. I believe that I'm a better person today. There was only way to go, either completely south or rise above and fight it, and I did. With all I had and with my sponsor and my family, they were so good to me. And with my higher power, first and foremost. It is the truth. It saved my life. Saved my life.
Mr. Sonny, do you have any other questions?
Just two more. What's your current sober date, Ms. McGinnis?
6 of 2015, June of 2015.
Thank you. And
I'm sorry, I didn't hear the answer. Your sobriety date was when?
June of 2015.
okay, and what step on the program are you?
I've worked with steps, but I'm working them again and with my sponsor, and we're on step 2, which is came to believe that a power greater than ourselves could restore us to sanity. And that step is, it's interesting because came to believe is the first part of it. And really, if you take the step seriously, you must come to that point. You must come to believe that a power greater than yourself could restore you to sanity. And in that step, we're not only identifying the fact that we were insane with our alcoholism. It drove us to insanity. And, but also to identify a higher power, to get to know what source, whether it be, this is difficult for many people, you see, what source, what will they visualize as their higher power? If you're a Buddhist or if you're a Muslim or whatnot, if you're, don't really have a denominational church that you go to, the ocean, the sky, the clouds. For me, being an Irish Catholic, raised an Irish Catholic, I, had a sense of God and whatnot, and a good one too. I didn't have a sense of an evil God, so it wasn't that hard for me to identify. But to build that relationship with your higher power, to trust your higher power, is what's key. You can't just say, "Oh, I believe in God." That's not going to cut it. It's something much deeper than that.
Thank you very much. At this point, Your Honor, I have no further questions.
Okay. Well, what I'm going to do is I'll open the floor to the board members to see if they have any questions of you at this time. So I started on my right last time, so this time I'm going to start on my left. So, Ms. Leon, do you have any questions?
Was there a particular trigger that brings you today?
I'm sorry, I'm having a real hard time hearing you.
Was there something that brought you today instead of next year or in the future to come and reinstate for your license?
Well, my profession, like I said, is of utmost importance to me, and I'm just anxious to be recertified. It means so much to me that I couldn't miss this opportunity.
Thank you.
Any more questions, Ms. Leon?
No.
Mr. Jacobson, do you have any questions?
I do.
Okay.
Ms. McGinnis, I want to make sure I understood the question and answer before. Is it correct to say that you have already gone through all 12 steps?
Oh, yes.
And now you're just redoing them?
Right.
And Mr. Sonic, what was the original charge what were the original charges in the accusation?
They're found at pages, the specific charges start at page 102, PET 102. So it was for an April 2007 criminal conviction for trespassing, lead alcohol.
I'm sorry, I don't mean what were the charges brought to the board for the revocation of the certificate?
Those charges, those various convictions, plus the claim for failure to report, and then the license was revoked when Ms. McGinnis failed to serve what's called a notice of defense in response to the accusation. And a failure to serve a notice of defense precipitates a default. It's sort of like in civil practice, and that goes to the board, and the board considered the allegations and evidence in support of the convictions and determined that without an opposition and request for hearing, they would revoke her license, which was done. At that point, she had, I believe, don't have this in mind, but I believe 1 year before she could seek reinstatement unless the board extended it. I think this was done in a timely fashion.
Do you know what the code sections are for not reporting the felony? I just seem to have missed it.
Yes, it's Business and Professions Code, section 5100, subsection G, in connection with 5063, which imposes the obligation to report convictions to the California Board of Accountancy.
Thank you very much.
Okay. Any more questions, Mr. Jacobson?
No, ma'am.
Okay. Mr. Familette, do you have any questions?
Yes, I have one question, Ms. McGinnis. So at this stage, are you comfortable that you have this issue managed and that you can return to practice?
Oh, yes, very much so. I'm currently working for a small company, and it's going very well.
Thank you. No further questions?
Thank you. Ms. Park, do you have any questions?
Yes, so you have 2 children?
I do.
So are you financially responsible for them?
Yes, partly. The education is paid for by the father.
Okay. So do you have any other family members, anyone else that you are financially responsible for, other than your 2 kids?
No.
Thank you.
Mr. Silverman, do you have any questions?
Just one, Your Honor. Ms. McGinnis, tell us about your job and what your responsibilities are.
I have a position now, a CPA that I met has a small, it's not an accounting firm. Basically, we have clients that we do bookkeeping, taxes, sales tax filings, issuing 1099s, all of that. We do it either remotely, we do it all remotely. QuickBooks Online, then we do their bookkeeping basically for them. We have about 50 clients. So it keeps us busy.
Any more questions?
No.
Okay. Mr. Savoy, do you have any questions?
Yes, Your Honor.
Okay.
If you received your certificate back, would you do anything differently in your job responsibilities or seek other employment now that,
I would, yes. See, having a license will definitely open many more doors for me.
do you have any ideas of what you'd like to do with the certificate back?
I think working in in the area of small business is where I like to work, kind of what I'm doing now, helping small businesses with their accounting records.
Thank you. No more questions, Your Honor.
Thank you. So Ms. Burhoff, do you have any questions?
Just one question. Has your employer expressed the opportunity for, to you, or expressed, how should I say this? Have they encouraged you to get your license back to be able to expand your job opportunities within the organization?
Yes, of course, yeah. Because, it's definitely, I can't, even on a business card, I can't say I'm a CPA. I'm not, you know what I mean? I'm not a CPA, and there's a big difference, as we know.
Thank you. I have no more questions, Your Honor.
Thank you. Ms. Hines, do you have any questions?
Yes, I have a couple of questions. Thank you for coming in today. Well, in 2015, I appreciate that was a time when when you relapsed.
Yeah.
But can you explain why you didn't respond to the revocation of your license at that time? Can you talk a little bit about?
Well, during that time, I was incarcerated.
Okay. And then can you talk a little bit about your employment history? In your application regarding the revocation, you indicated that you've been employed or had an employer since 2009. Can you talk a little bit about your employment history? Were you always employed during that period of time? Did you have some periods, not including the
always.
periods where you're incarcerated, but were there periods of time where you were not employed?
Right, there were periods when I was not employed.
Okay. All right. And I actually had a question for Mr. Sani. Was the revocation based upon the 2015 conviction? Is that what flagged all of this process? Put all this into motion?
That's an interesting question. When we go through the process of having licensees who've been convicted, there is a mechanism by which courts will notify the board of a conviction, an arrest, and so forth. I do not know exactly what precipitated this, but once the board identifies that there's been some sort of activity that's in the criminal system, they may have referred it to the Department of Justice, to our office, frankly, to me, and we would then do a check, identify all the supporting criminal records, and make sure that we've captured all the relevant convictions that might be the subject of an accusation. They're then drafted into the accusation and filed with the board. But I can't tell you right now what precipitated it. My suspicion is you are correct that it was the 2015 one, but it could have been earlier, and we were just doing a catch-up as more proceedings occurred.
Okay, thank you. And then I just have one more question for Ms. McGinnis. When we're looking at your license history, you did renew your license in a timely manner throughout this entire period of time. So at no other time during your renewal process did you report the earlier convictions? Is that correct?
That's true, yeah.
Okay, all right.
Any more questions, ma'am?
No, thank you.
Okay. Mr. Campos, do you have any questions?
Yeah. To clarify the completion of the 12-step program, was that subsequent to your last or your sobriety date that you mentioned in 2015?
Yes, I went through I did the steps all over again. And in fact, now I have one woman who wants me to be her sponsor. So I'm excited about that.
Thank you. And Ms. Wright, do you have any questions?
I do. You've indicated that you're looking forward to a bright future and so forth if your CPA license is reinstated. The world of accounting involves a number of rules, regulations, and statutory provisions. What's your perception now of the rule of law, so to speak? If there are rules and guidance issued by regulatory authorities and so forth, and you're doing whatever you may pursue in your career in accounting or tax, for
Right.
that matter, if you encounter all of these rules and regulations, some of which you may agree with and some of which you might not agree with, what's your perception now with respect to how you will respond to, quote, the rule of law?
Right. All organizations, the California Board of Accountancy and all of those similar there too, all of their laws, regulations should be known clearly, concisely, and should be adhered to, which is where I failed. I should have reported those. And in the earlier conditions, I wasn't aware that I had to, but still, there's no excuse. I should have known all of these rules and regulations. But I fully intend to follow all rules and regulations for all organizations that I'm a part of.
Any more questions, Ms. Wright?
No, thank you.
Thank you. All righty, so I wanted to go back to you, Mrs. Soni. Do you have any follow-up questions for Ms. McGinnis based on the questions that you heard from the panel members?
No, I mean, I have a closing remark or two, Your Honor, but no questions.
Okay, and Ms. McGinnis, do you have any further testimony you want to offer in response to any of the questions posed to you?
I just want to reiterate the fact that my profession is of utmost importance to me, as is my sobriety, and I will do everything I can to get it reinstated, and I will continue to uphold the ethics of the profession if I am reinstated.
Okay, thank you, ma'am. So I'm ready to hear closing arguments at this time, or closing statements, or closing remarks. So I'm going to go to you, Mr. Soni. What do you have to say at this time?
Thank you, Your Honor. Obviously, in cases involving a number of convictions, it's a serious matter. They're over a period of years, indicating obviously a serious problem. The burden of proof in these proceedings is upon the petitioner by clear and convincing evidence to show rehabilitation and that she would be safe to practice. Ms. McGinnis has provided a significant amount of evidence indicating rehabilitation. It's for the board to determine if that burden has been met. If the board determines that the burden has been met, on behalf of the people, I would make a couple recommendations for the board to consider. One would be the board could do one of two things, or both. One is it could impose alcohol terms under the disciplinary guidelines. It may be, though, that another alternative way of proceeding is to have a 5-year period of probation, and in the event that Ms. McGinnis were to be subject to another criminal conviction, 5 years would probably manifest that conviction and provide notice of a problem that has not been resolved. So the only other issue that to me is a little bit uncertain here, and that's because Ms. McGinnis is a lay person describing the criminal process. The accusation did allege that the 2015 conviction imposed 5 years probation, and Ms. McGinnis indicated that she is in the process with her attorney of reducing that felony conviction to a misdemeanor, if I understood her correct, but she believed that she was not under probation presently. That may be true because when you go through this process and go into community work programs, the judge can modify the sentence. We simply don't have a record of that here. My recommendation would be that if the board does impose probation, it require that Ms. McGinnis comply with the terms of any criminal probation that is outstanding presently, and that if she fails to comply with the term of probation, that would constitute a violation of the probationary order of the board, for which we could then actually commence proceedings to revoke her license. That's another way of kind of catching any problems that were to occur in the course of probation. Obviously, we all want and hope and expect that Ms. McGinnis has this, severe problem that she had under control, but the probationary mechanisms would provide an avenue of ensuring public protection during the period of probation.
Mr. Soni, I just had a quick question, just for clarification. You're recommending, if I understand you correctly, if the board determines that Ms. McGinnis has shown the requisite amount of rehabilitation to warrant the reinstatement of her license, that she be placed on probation, but the conditions are instead of the typical alcohol conditions, to instead have a condition whereby she's tracked by her remaining criminal probation conditions, and if anything happens during that period, the board would be alerted and then proceed? Is that what you're?
Yes, in fact, that's correct. So she would be subject to standard terms of probation, obviously with no costs, since this is a reinstatement, although the board could impose costs, that I won't speak to. But then the additional term would be, I could even kind of give Your Honor a flavor to the extent of what that term might say. It would say something like, respondent shall comply with all the terms and conditions relating to her criminal court probation, if any, in the matters entitled People of the State of California versus Molly McGinnis MacArthur, etc., in Orange County Superior Court, case number 13WF1194, and including any term that would be imposed that would relate to the alcohol programs, whether she was required to attend alcohol-related programs. And then I would add this language, Your Honor, perhaps as a suggestion. If a respondent violates probation in any respect, the CBA, after giving respondent notice and an opportunity to be heard, may revoke probation and carry out the disciplinary order that was stayed. If an accusation or petition to revoke probation is filed against respondent during probation, the CBA shall have continuing jurisdiction until the matter is final, and the period of probation shall be extended until the matter is final. And I believe that provides a certain amount of public protection by virtue of a 5-year probationary period, and would not maybe need the alcohol terms. Ms. McGinnis does have, for example, and she is subject to an ignition
Interlock device.
interlock device in her car, which by itself to me suggests that there is some continuing monitoring that is taking place, and so she would be subject to all those terms. And the ignition device is itself a way of alcohol testing in effect. If she wants to drive, she has to pass that alcohol test. So it seems to me it might be somewhat burdensome to require alcohol testing above and beyond that which has already been imposed, but it's the board's discretion to determine what appropriate mechanism is in the interest of public protection.
Thank you, sir. All right, so I'm going to go to you, Ms. McGinnis. And this is your opportunity to make any closing remarks that you wish at this time.
Well, we've gone through, what my convictions were. I've given you kind of an idea of what happened, really, because there's a story always with these situations, and that's my story. And fortunately, the story has a happy ending. And I just can't tell you how grateful I am to be here today, to be alive, and to be able to contribute to society as a CPA. I mean, in the future, I'm hoping to really become clear-minded and have many moments of clarity where life is looked upon as not so much of a challenge in terms of when things change and we are not in control. We must learn to go with the flow and not resist change, because for me, that caused problems. But I'm learning every day how to manage my life so that it is a peaceful, productive, happy life.
Thank you, ma'am. So, unless there's anything further, I'm ready to go off the record. Do you have anything further, Mrs. Soni?
No, thank you, Your Honor, President, members of the board.
And Ms. McGinnis, do you have anything further?
Oh, no, thank you.
Okay, so this matter is deemed submitted as of this date, September 15, 2017. We are off the record. Thank you very much, everybody.
Thank you.
Okay, so what we're going to do at this point, we moving into closed session pursuant to Government Code Section 11126C3, the California Board of Accountancy will convene into closed session to deliberate the decision after remand, Ned Leba, CPA license number 23912. Pursuant same code, the California Board of Accountancy will convene in closed session to deliberate the above petition with Molly Aaron McGinnis. Additionally, the Board of Accountancy will convene in closed session to discuss disciplinary matters, stipulated settlements, default decisions, proposed decisions, and decision after non-adoption. And finally, pursuant to Government Code Section 11126E, the California Board of Accountancy will meet in closed session to receive advice from legal counsel on litigation David Greenberg versus California Board of Accountancy, Los Angeles County Superior Court, case number BS 155045. We are now in closed session. Okay, the California Board of Accountancy is now back in session. It is September 15th, 2017. My name is Alicia Burhan. I'm the president of the board. I'm going to go back to real quick on section 3B on the agenda, review of the California Board of Accountancy fund condition and consideration of possible fee changes. We are moving this item to the CBA meeting in November. Are there any public comments? Okay, with that, we will go ahead and take this item, moving forward to the November meeting. At this point, I think we are going to be good to go. We are going to be going ahead and adjourning the meeting for today, again, September 15th, 2017. Our next meeting will be in November. Thank you very much. Have a great day. We are adjourned.